Ms. Storage is sitting next to defendant at table. Ms. Carey, the prosecutor, is here. And we were in the middle of the plea taking process. The court had covered the charges. The court had covered the pretrial agreement. And the court had covered the rights being waived. If I didn't cover it earlier, there was a request for criminal responsibility that was received by the court on January 6th of 2026. Mr. Hartel, did you get a copy of that?
Yes, sir.
And did you feel any need to request, if I didn't ask this earlier, any independent evaluation to continue?
No.
No? All right. Just want to make sure you know. All right. Mr. Hartel, are we able to proceed? I was allowing him some time for questions. Is there anything that I need to be told that's going to change the process?
No changes. He just wanted to double check a few details.
Sure. Okay. Mr. Failer, were you, I know I gave you plenty of time there. Were you able to talk to Mr. Hartel about whatever questions you had?
Yes, Your Honor.
And did you talk to Ms. Storage at all about it?
Yes, Your Honor.
All right. And were you satisfied they gave you answers and answered all your questions?
Yes, Your Honor.
Do you still wish to continue with this pretrial agreement that we went over earlier?
Yes, Your Honor.
Do you need me to recover, go over again, the pretrial agreement, any of your rights or anything else?
No, Your Honor.
All right, thank you. Well, there it is. Has anyone made any promises to you, Mr. Failer, as to exactly what the sentence would be?
No, Your Honor.
Okay. Anything that's been told you is merely an estimate or guess so far by Mr. Hartel. Do you understand that?
Yes.
Now, he's probably got a pretty good idea what I'll do because he appears in front of me all the time, but I just need to make sure you understand that when it comes to sentencing, I alone will determine that sentence. Do you understand that?
Yes, Your Honor.
All right, good. Do you have any questions of me before I take the plea?
No, Your Honor.
Do you have any questions of Ms. Storage before I take the plea?
No.
And do you have any other questions you need to ask Mr. Hartel before we do so?
No, Your Honor.
All right, thank you. Now, I need to find my plea sheet again. Just a minute. Somebody remind me what we're doing. I don't have my plea sheet. 1 second. Okay, I recall this. Count one, he's pleading no contest to the unlawful driving away of the Chevrolet track from Ms. Walter, correct?
Yes.
That's it, yep. And he's also pleading guilty to count two, the failure to report fixtures, correct? Count three, home invasion first will be dismissed. Count four, unlawful driving away of that vehicle.
Was
will
it
be
Chevy Trailblazer?
Chevy Trail, oh, okay, Chevy Trailblazer, that will be dismissed. Count five, operating while intoxicated will be dismissed, and count six, assault and resisting obstructing a police officer will be missed. However, he will be pleading no contest to an added count seven of home invasion third degree based upon a lesser included of count three, home invasion first. He'll be pleading no contest to operating while visibly impaired, which is a lesser included for count five. And he'll be pleading no contest to an added count seven of attempt to assault resist a police officer. Is that right?
Correct.
Mr. Hartel, did I get it right?
Did we do 8 and 9?
I'm sorry if I said it wrong. Count seven is the added count home invasion third. Added count 8 is operating while visibly impaired. And count 9 is attempted assault resist obstruct a police officer. I didn't say the numbers correctly the first time I did it there. Everybody agree there, Ms. Perry
Yes.
and Mr. Hartel?
I would also concur with that.
So now comes the time for taking your plea, Mr. Failer. Again, I anticipate you're going to tell me no contest. I'm not instructing you what to tell me, but I'm just telling you that's what everybody's told me you're going to do. I say that because people watch too much TV. On TV, they always say guilty, not guilty. So I expect that you're going to answer no contest. As to count one, unlawful driving away of a motor vehicle, specifically a Chevrolet Trax. How do you plead?
No contest.
As to count two, failure to report an accident to fixtures, a misdemeanor. How do you plead?
No contest.
As to added count 7, home invasion in the 3rd degree, a felony punishable by up to 5 years. How do you plead?
No contest.
And as to added count 8, operating while visibly impaired. How do you plead?
No contest.
As to added count 9, attempted assault, resist, obstruct a police officer. How do you plead?
No contest, Your Honor.
Before the court can accept the plea, the court needs to consider some exhibits. Mr. Hartel and Ms. Carey, I have before me People's Exhibit number 1, which is a City Department of Cadillac Police Report with an incident number of 25-761. And I have and that, by the way, consists of 3 pages. People's Exhibit number 2 is a City of Cadillac Police Department report, incident number 25-762. Now that consists of initially a 7-page report with some attachments. And People's Exhibit number 3, which is a Michigan State Department of Police Forensic Science Division report. That goes along with the City of Cadillac Police Department Incident Report number 762, showing a blood alcohol content draw. One more. Now, and People's Exhibit number 4, also from the Michigan State Police Department Forensic Science Division, also for the incident report ending in 762. Any objection to the admissibility of those documents?
No.
People's Exhibits 1 through 4 are hereby admitted. The court first makes a finding that the reported date of the offenses is on March 27th or on or about March 27th of 2025. And the report demonstrates that they occurred within the City of Cadillac here in Wexford County. Court makes a finding as to count 1. The facts there are described in People's Exhibit number 1, which again consisted of 3 pages. And specifically on page 2, there's a statement from the owner of the vehicle, Miss Sue Lewis Walter, and it discusses the taking an unlawful driving away without her permission of a Chevy Trax vehicle. As to count 2, As to count 2, failure to report the accident causing damage to fixtures is also covered on page 2 of 3 in People's Exhibit number 1, specifically describing damage done to the electric sign out there in front of the Cadillac High School. Now turning to added count 7, which is the home invasion third. The court is now looking at exhibit number 2. This deals with a residence in the city of Cadillac. And describes on page 3 of 7 information regarding entrance into a residence owned and or maintained by another individual who is not the defendant. Page 4 of 7, there is a description of taking an item from a residence or a garage on the street. Also, that when the defendant was later found operating a vehicle, that he failed sobriety field tests and a search warrant was obtained through Munson Hospital and vials of blood were taken to determine his blood alcohol level. And that takes me to exhibits 3 and 4. It's noted that in 3, the defendant had THC in his bloodstream and that he had a blood alcohol level of 0.079 also at the same time. While the 0.079 is not a per se drinking and driving or operating while intoxicated, that added to the marijuana addresses the operating while intoxicated, which allows the court to take a plea to operating while visibly impaired. Also, the findings that I see here in the exhibits regarding the home invasion allows the court to take a plea as to the home invasion third, which is the added count 7. And then now we turn to the added count 9, which is the attempted assault resist obstructing police officer. Well, I see here in exhibit number 2, there was resistance of complying with preliminary breath tests, but I also see. Yeah, but I thought I read that, so I'm looking to find that. It looks like there were a couple officers involved. Particularly here, this deals with Officer Grum of the police department here in Cadillac. Yes, I see that on page 4 of 7 in exhibit 2, it discusses the failure to comply with the instructions of a law enforcement officer who was in uniform and was performing his lawful duties. Ms. Carey, do you believe the interest of justice did not require the court to demand a factual basis from the defendant?
I do.
Are you aware of any other promises, threats, or inducements?
I'm not.
Do you believe the court is in compliance with Ms. Scroll 6.302?
Yes, sir.
And do You believe that the exhibits 1 through 4 contain the element, facts to support the elements for the counts to which he has pled no contest.
I do.
Mr. Hartel, do you agree with all those answers?
I do, Your Honor.
Thank you. The court agrees and finds the interests of justice do not require the defendant to recite a factual basis based upon civil liability potential. Also, the defendant had multiple substances in his system when he was operating the vehicle. The court also finds that the information contained in exhibits 1 through 4 satisfy the elements for the counts to which he has entered pleas of no contest to. Therefore, the defendant is found guilty of count 1, count 2, and then adding counts 7, 8, and 9. The remaining counts will be dismissed at the time of sentencing. All right, Mr. Thaler, this case will now be set for sentencing. We do sentencing in this court every Monday morning. And they generally are about 4, maybe 5 weeks from this coming Monday. Between now and then, an agent from the Michigan Department of Corrections is going to prepare what's called a pre-sentence investigation report. One of these reports must be prepared anytime someone's convicted of a felony in a state court here in Michigan. This report will include a description of the facts, description of the pretrial agreement, any statements or information you make while it's being prepared, as well as information about any prior criminal history you do have or don't have. It will also include descriptions about how you've done on bond, how you've done on probation, in this file or prior cases. It will also include a score in the Michigan sentencing guidelines, which again are not mandatory. And also it will make a recommendation as to the sentence. Whatever recommendations are in there are strictly that, just a recommendation, as it is this court alone that will determine the sentence. There are 3 steps that involve you for the preparation of that report that I just mentioned. Step 1, you're going to get a packet, and the clerk has just handed it to bailiff Longstreet. You'll get that, you'll take it back with you to the jail. You'll complete as much of it as you can and turn it back in. Number 2, you'll be subject to an interview with an agent from that office, and you have the right to have Mr. Hartel present during that interview. And number 3, generally about 10 days, maybe 2 weeks before coming back here, that report will be provided to Mr. Hartel, and he'll have to meet with you and go over it. Why is it important that you go over it with them? Well, because you may have forgotten something, you want to correct it. You may have remembered something and you want to add it to the report, but each side also has the right to come back to this court, make objections to whatever's in there, or make requests for changes. You understand?
Yes, Your Honor.
All right. So, Mr. Thaler, we've talked a lot today, and I know you've got some good helpers here with you. I just want to ensure, do you have any questions for me about what we have done today?
No, Your Honor.
Okay. Again, are you satisfied with the guidance from Ms. Storage and Mr. Hartel?
Yes, Your Honor.
Great, thank you. Ms. Carey, I'm going to revoke bond, but it's probably, well, anyways, I'm just going to revoke bond, remand him into custody until we get back here for sentencing. How long has he been in jail?
I don't remember the exact number, but I know it's been quite some time.
Yeah. Well, anyways, that's going to be the choice of the court. Let's take a quick look. Well, this case has been up here since November 20th.
About, I'm sorry.
Sorry, we received it May 21st.
So it's coming up on a year. Has anybody done guideline scoring?
Yes, Your Honor, I believe 10 to 22 on the guideline minimums is what both myself and Ms. Fioventa, because we've been working as a team on this case.
All right. So it's a 10 to 23 likely, and right now he is at, you said we got it in April? No, May.
We received the file in May, the offense date was March.
So,
We had a
Close.
juvenile case at the same time.
okay. Oh, there were other cases?
He was in a program through juvenile court during the time of this as well.
So if there's any request to modify bond, I would want it in a brief so I can know more about Mr. Thaler. At the same time, though, if it's a 10 to 23, by the time we come back, I'm going to imagine that he's going to be looking at, let's say it's a year, he's going to get time for credit. He will have served any confinement period. That makes sense. So I don't know anything more about it. That's up to the parties. I've got another case to resolve here today. Anything else, Ms. Carey?
No, thank you.
Anything else, Mr. Hartel?
Not for today.
And Mr. Taylor? Andrew, do you have any questions for me?
No, Your Honor.
Thanks. Mr. Owens, do you have any questions? George, I'm sorry.
No, this just gives us time to figure out where he's going after.
Good. I hope you all find a good place for him.
I
Mr.
think we're
Taylor?
going to relocate.
Well, he'll be missing all the great things Cadillac and Westwood County have to offer, but sometimes a change of scenery and a change of location can be helpful. All right, well, good luck. We'll see you all in about 4 weeks. Thank you.
Thank you, Your Honor.
Ms. Carey, your exhibits?
Well, the next thing is the sentencing. I don't know what.